A paper is drafting. B paper is defending. And C paper is about opposing, that is attacking. So in all the cases, basically you apply the same novelty inventive step principles, but from another angle. For example, in a paper, you have a client writing to you and describing to you some technology, like, I don't know, optical mouse, whatever, and also presents to you some prior art documents like D1 to D3. And it's your task to, based on the information from the client, to understand the invention, understand the differentiating features of the invention over D1, D2, and D3. Maybe you will have more. And then draft claims, tentative claims for the invention. This is A, basically. In B, on the other hand, what you do is this time you have a file where you already obtained the extended European search report. So there is, you all have seen EPO reports. I mean, there are some official objections. The examiner will tell you that there is no clarity, there is addition of subject matter, there is maybe the claim is not novel, maybe claim 3 is novel but not inventive. All right, substantive law. What is substantive law? 52, 53. Maybe you will have a presentation of information which is non-patentable. All right, I don't know. You will have some problems in the report. Substantive law 52, 53, 54, 56, 83, 84, 123. All right. So you will need to also consult with your the letter of your client, because the client has already seen the report and she has some ideas, and you will need to make your plan, make your way through to amend the claims. When amending, you will have some problems because one of the prior arts, will prevent a larger scope of protection, but you will have some fallback positions in one of the claims. So you will need to find that, all right? And you will need to ask yourself, if I limit my claim with this claim 4's features or claim 7's features, will that be also fit to overcome the objections in the EPO's report? Because EPO's report will tell you what is not inventive. But this will also provide some information also about what can be potentially inventive. All right? Together, in combination with the information in the letter, you will write the claims, amended claims. You already have a claim set, but this time not from the scratch, but working on the existing draft, because you will also be provided with the claims on file. You will have a chance to amend the claims. This is part B. Oh, no, sorry. B-type exam. And C-type exam is, this time you oppose a patent. All right, you have like a number of counter documents, D1, D2, D3, a certain number of documents, and you have a EPO granted patent, and it has a claim set, like 6, 7 claims in old days. Typical paper C has 6, 7 claims, and you have 6 prior art citations, and you start reading A1, which is Annex 1, which is the patent you oppose. All right. In the C style M1 paper, we will have a simplified, much more compact version of this. This is what we believe, because the regulation and implementing provisions allows for a versatile style exam. I mean, although the mock EPO is B type, we should be expecting, I mean, I have also discussed this, we can be expected and we should be ready to face other scenarios like C type and A type. All right. So in C type, this time you have a claim set to attack, and you argue that claims are not are not fulfilling requirements of the EPC. You say claim one is not null because there is D5, this publication, earlier dated publication. Claim 2 dependent to claim 1, and it has two alternatives. First alternative is entitled to priority 1, and second alternative is entitled to priority 2. Second alternative is not novel because the same publication destroys novelty, but the other alternative has an earlier date this time, and the same prior art no longer usable as 54.2 document, etc. So very basically, in A, you draft. You have the invention from the client and also prior art list. In B, you have the EPO report. You have the draft claim set or on-file claim set, which is problematic. EPO has many objections, and the client has some views. You correct it. You amend it. In C, you have a granted claim set, and you have a number of prior art documents. You argue that in view of those documents, the claim set is should have not been granted in the first place because the documents are either destroying novelty or inventive step, etc. So this is the very general